I'm delighted to introduce you to today Despoina Mantzari, who's coming to us from UCL Laws. And some of you with longer memories may recall that she spent some time in the past. And now we're going to hear her today talking about FRAND and the DMA. I'm very curious to hear what you will be arguing.
Thank you very much for this kind invitation. It's always a pleasure to be back. This is giving my first academic job at postdoc in 2013, 2014, and I see that my former boss, Morton, who hired me at the time, and I still believe it is an amazing place, especially as an early career researcher, to work and interact with both economists and political scientists. And I'm very, very, I very much miss these teas, 11 a.m. at the galleries for tea at the CCP. So I am, so for a long time, my research looked at, let's put it this way, like tangible assets, right? Like the network industry, the energy, the telecoms, and I'm now moving from the tangible economy to the more intangible economy, looking at platforms and the DMA, of course. So I have to confess that for a long time I stayed away from writing or commenting on any aspects of the DMA till actually it became real, till we had some designation decisions, the regulation in place. And what really caught my attention is the FRAND provisions in the DMA. There are two FRAND provisions in the DMA. One relates to search engines and the other one to app stores. And I will be focusing today on the latter. Now, on search engines, it is actually, it imposes on the gatekeeper an obligation to provide to any third party undertaking providing online search engines, for example, Think, at its request with access on fair, reasonable, and non-discriminatory terms to ranking, click, and view data. So that is actually a provision that regulates private party access to data targeting gatekeepers who provide online search engines as a core platform service. There we have contestability, mostly concerns, and the recognition that data is an essential input for competition. We have a tension between privacy and contestability, and I think this opens the discussion on how to think about these issues in light of the Data Governance Act. And I have some thoughts on this maybe later, but I will move to the core FRAND DMA provision that I will be concerned with today, which it's about platform FRAND access. So Article 6.12, which is here the relevant provision, says that gatekeepers shall apply fair, reasonable, and non-discriminatory general conditions of access for business users through its software application stores, online search engines, and social networking services. And the gatekeeper will have to publish these general conditions of access, including an alternative dispute settlement, and the Commission shall merely assess whether these comply with this paragraph. So that is what Article 6.12 says, and it is mostly, I think, drafted with the Apple iOS store in mind, given battles ongoing at the time with the Dutch competition authority and other authorities. Now, looking at first out the FRAND provision, I saw that there is an ever-growing list of EU-derived obligations to provide access to services, non-replicable infrastructure, utilities regulation, and of course, patents. But you find FRAND provisions even in the REACH, the chemical regulation, in Horizon. It is actually, I have a nice table in my book on where we find FRAND terms in EU law. And you see that the level of detail of what is FRAND varies significantly from context to context. You have, in some areas, very high-level principles, For example, that a price should be fair, reasonable, and non-discriminatory without giving any substance to these terms, to very detailed methodologies of how actually the price should be set. In the FRAND SEP licensing, this has been held up by excessive litigation and rather inefficient deal making. And if we look at the experience in standard essential patents, we see two approaches. One that is very much rules-based, which is the Unwired Planet litigation in the UK, versus a more procedural approach to FRAND, which is a court of justice in Hawaii. So the question is the FRAND experience here useful? How to price digital access, and what is a fair price for intangible resources? Now, my argument is that we need some guidance on what is fair and reasonable compensation in this context, that the Commission is not willing to give at this moment. It doesn't want to go anywhere near telling us what FRAND is, not even at the level of high principles that I argue are essential here. I am not arguing about setting out a detailed methodology on how to calculate what is a fair and reasonable access for business users to app stores in this context, but because this would limit the flexibility of the parties involved, and it would be very much unlikely to be future-proof, and we shouldn't be caught up in an illusion that a catch-all reference to FRAND would be enough to manage such heterogeneous transactions. But I think the Commission could lay down some principles that would be the lower bound and the upper bound of FRAND, and I have some ideas in this context that I will share. Now, why the Commission should do that? Because if we look carefully in the DMA from our legal lenses, we'll see that then the business users have very limited opportunities for meaningful redress if they do not consider the terms FRAND. So the DMA has been drafted in a way that very much constrains judicial review. It relies on more consensual character. There are various, I can discuss later, examples where the DMA does not even require the Commission to adopt a decision that can be challenged by means of a direct action. They only have private enforcement that it will take some time to pick up. So actually here we do not only have an asymmetry in bargaining power between the App Store and the business user, but we've got also a broader imbalance that creates a win-win situation for the Commission, because it doesn't need to get into the dirty business of pricing intangible assets and becoming a price regulation, but that at the same time, this pragmatic approach creates unintended consequences for the very interests that this provision seeks to promote, that of business users. So if we turn to FRAND briefly in EU law, we shall see, for example, in BEREC, in telecoms, FRAND should represent a balance of interest between the company which owns, holds an asset, product, a company enjoying a significant market power, and those companies that need to access or use this product in the context of access to telecommunications infrastructure. So we've got a FRAND provision in telecoms, and Ofcom in the UK has very much also applied FRAND terms in regulating wholesale access. In competition law, that I think is the closest parallel in this context, we have the well-known cases on compulsory licensing, McGill, IMS Health, and I will focus mostly on Microsoft. So Microsoft, the interoperability Microsoft case, there we have obligations to provide interoperability information, which was covered by copyright, for Microsoft's workgroup server operating systems on reasonable and non-discriminatory terms to Netscape to its rivals in the Windows group server market. So that was a remedy, right, that was a non-consensual FRAND-like obligation that was imposed on Microsoft as a remedy for its Article 102 violation. And I looked at the Commission decision, you can see, but it could tell what is FRAND in this context. It is not so difficult, at least lay some principles. And further proceedings examined whether Microsoft licenses properly implemented the Commission's decisions and whether the royalties that were charged by Microsoft were excessive. And in further proceedings, Microsoft breached its obligation to offer reasonable and non-discriminatory terms, so the Commission could exercise a powerful check on their royalties. And interestingly, and this is where we can draw a parallel with France, as we shall see in a minute in the app stores, for the remuneration to be reasonable, it had to represent fair compensation for the value of the technology that is transferred by Microsoft beyond the mere ability to interoperate, namely excluding the strategic value stemming from Microsoft's market power. So Microsoft could not take into account, right? What the Commission would not take into account was this strategic value stemming from Microsoft market power. So Microsoft had to evaluate whether its terms were aligned with the value of comparable technologies, and that is what happens in the sort of SEPS also context, but excluding its market power. And that led to a further challenge before the General Court. I shall return to this point in a minute. I think this provision is also very much inspired also by excessive pricing. So when the Commission talks in the DMA about unfair terms and conditions, then we can turn to the Aspen case. The Commission considered that the price of the drugs was unfair in itself due to the fact that Aspen did not offer any material improvement of the products or any justifications to reflect commercial risk-taking activity, innovation, or investment. And in relation to the discrimination component of FRAND, authorities and courts have addressed pure second-line discrimination in mail and price and non-price discrimination in the case law concerning margin squeeze and self-preference. So the reason I figured out this case was because there is an acquis deriving from the case law and decisional practice on which the Commission could build, and it has done it in the past in the Microsoft case.
Okay.
Now, yes?
Sorry, yeah, if you go back to the two slides back. So this strategic value, was that defined at all in the?
It was the, it's market power, right?
It's
actually.
market power.
Yes.
Strategic value is market power.
Yes, it's market power, yeah.
Let's see.
So they
which
should
had
charge
to be-
essentially the average cost of transferring the technology, nothing more.
Nothing more, yes, that's correct, that's correct.
Because if they meant market power, why didn't they say market power? That's kind of my
Yeah.
question.
Yeah, because it gives us maybe is it comparable to the architectural advantage you have? The platform being a super sort of dominant firm. I found that is an interesting point to look at.
Probably Google Translate.
Yeah. It could be the Google Translate, yes. In patent licensing, the objective there is to make SEPs available at the price equivalent to what patents would have been worth in the market prior to the time they were declared essential. So again, you want to take out of the mix, right, the market power. So again, there is no general here agreed upon test to determine whether a license satisfies a FRAND commitment. We have the rule-based versus procedural approach. The court, instead of defining the meaning of FRAND, imposed the procedural framework for good faith negotiations, and I think that is what the Commission is trying to do here. It says, you know, we'll stay away from laying down pricing principles, and I'm going to be here the sort of regulator of this
process, of this bargaining process between the app stores and the business users. Now, if the SEP owners need to show that their offer is FRAND, if they fail to do so, they will lose on FRAND and no injunction. Now, the SEP owners, what will they do in order to convince? They will disclose comparable license agreements with similarly situated companies, top-down analysis, third-party essentiality studies, and that is how they will, these are the benchmarks they will use in order to value their licenses. Now, this is pretty much a very sort of brief overview of the acquis on FRAND, telecoms, competition, exclusionary, and licensing. And we will see how this provision of the DMA draws on pretty much all of them and what can we offer. So the goal of Article 6.12 is to facilitate, of course, access to this essential infrastructure, which is an app store, and to generate more competition downstream, or even the development of a rival infrastructure, and to redistribute some rents. So I think it very much encapsulates the trade-off between contestability and fairness. So when I presented this piece of work in Germany, some of the scholars said, no, it's only about fairness. I said, no, it's also about contestability. Because if the FRAND access price is too low, then this will, of course, undermine the incentives of the gatekeepers to contest the relevant core platform service. And if it is too high, it will fail to address the power imbalance.
What do you mean by contestability in this context?
Challenge the position of the gatekeeper.
So not contestability in the sense of old-fashioned regulation.
No, contestability.
So it's just
in the
competition.
Yes, competition, exactly. Yes.
Yes, we have a question online from Jens.
Yes.
Yes, thank you. I have a brief question. And so on the previous slides, kind of the examples that you mentioned, starting from Espen, these are all tangible goods markets, as far as I understand, and they are subject to relatively simple economic effects. So what you're talking about here in the context of the DMA is rather complex. We have all kind of network externalities and what have you.
Exactly. I will get to this point in a minute. Yes.
Because, so, I mean, just given this, maybe you can prequel kind of to which extent you think that we can learn any useful lesson from the existing case law here.
Yes, I have the punchline in a minute. So again, if we look at the DMA recital 62, the benchmarks are very much inspired by the SEP's valuation I was talking about and the analytical framework of exploitative abuses. They're talking about terms and conditions imposed for the same or similar services by other providers. They're talking about prices charged or conditions imposed by the provider for different or similar services to the different type of users. They're talking about different geographical regions, which is very much, again, close to the case law. Prices charged or conditions imposed for the same service the gatekeeper provides to itself. So we see that the benchmarks draw from SEPs and from the analytical framework of exploitative abuses.
Are you basically talking about app makers over here?
Yes, yeah.
So it's purely for the app makers?
Purely for the app makers, yes. So here we have a trade-off when we are trying to think about the fair and reasonable access price between allocative and dynamic efficiency. And we can think of cost-based versus value-based approaches to access, right? And that is, I'm not going to go further into the economics. What I think, if we go down the rule of value-based approaches, we need to determine, as the Commission did in the Microsoft case, what is the economic value of the platform, right? One way to determine the FRAND here rates is in relation to the economic value of the platform. And this is absolutely consistent with the logic of FRAND in SEPs. In SEPs licensing, we expect royalties to reflect the economic value of the technological standard, which is driven by the value of the technologies that are incorporated in it. For example, an improvement from 4G to 5G may be of value to the end users, but also to the handset manufacturers, because it allows them to watch videos, download their favorite movies of a better quality, right? So the greater the economic value of the technology, the more the end consumer would be willing to pay for a device that incorporates it. And then the higher the royalties that can be charged in this context. Now, the economic here value of the technology in SEPs is given by the incremental value of that technology to consumers relative to the next best alternative. But when we turn to the application stores, much of the value attributed to them is generated by network effects. So the value, therefore, of the platform, of the gatekeeper platform, may not solely be informed by superior technology, but by the network effects that are generated by the market in question. And the question I have for you, I think, an answer, is whether gatekeepers should be remunerated for the control of such network externalities. I mean, at some point, these network externalities kick in, right? And we have the winner takes it all effect. I mean, if we remunerate, if we take into account the network externalities, from my research in a SEP context, this would equate with remunerating the SEP holders for the holdup conferred upon them by the standardization process. Right? So what we do is we try to exclude the market power that they would. We try to do the same in Microsoft. I think such an approach would not be compatible with the DMA.
I'm not convinced of the value of the network effect. So Facebook built up value in network effects from scratch. Apple and Google have an artificial bottleneck which has created network effects, because if you have an Apple phone, you have to use the App Store. So I challenge the idea that there's value that should be rewarded.
It shouldn't be rewarded.
Shouldn't be rewarded.
It shouldn't be rewarded, yes.
Is that what you're saying?
Yes,
Okay, sorry, I misunderstood.
yes.
Okay, yeah.
This should not be rewarded. It is not in the same, it's not in the same way as in the sub-country would reward a superior technology, right? And the effort sort of in innovation. The same said before, even in the context of exploitative pricing in Aspen. This does not derive from any of your efforts, you know, to innovate. This is something very peculiar, I think, to this market. And if we remunerate them for the control of such network effects, this would not be compatible with the goals.
I think you guys are agreeing on different parts. You're both agreeing that they shouldn't be remunerated, but he's saying there is no value generated from the network effect. You're saying there is.
I say there is, yes, I say there is
Yes, I'm
value.
saying there's no value.
There is no value.
Yeah.
I didn't dare to go that far.
Yeah.
I think there is,
Because it's a symptom of monopoly. It's not something that has been built up
that
through
has been
innovation.
built through innovation, yes.
I mean, if the network effects is the reason why we've invested in the first place, then it kind of would be weird not to take that into consideration. If you write about this, of course, nobody who writes a book should have any rights to the film or the merchandise, anything like afterwards, because that was not part of their contemplation when they invested in writing the book in the first place. So this is pretty controversial stuff.
So simply, I say that we shouldn't remunerate them for the value, right? But I think.
How do you avoid turning this into essentially regulating profits? Is where my problem is.
I would have thought that the value is there even from the network side, simply because if you had, let's say, 50 small Apple stores, then people don't know which store to go to. So just the fact that there's more and more apps in one location makes it easier, and that's creating a value in that sense. Whether Apple should be allowed to reap that benefit is a separate issue, but I'm saying the value is coming from the fact that it's one guy selling all the apps rather than 50 people selling.
So the value, I think we agree that the value associated with what we see reflects the monopoly power, right? I'm not sure if
Sorry,
we
go-
are talking
go-
past each other.
Yeah.
I think that the value here reflects the monopoly, the monopoly power. They have already won the gatekeeping race, right? And then this is reflected in the value of network effects. I say that we should not remunerate network externalities. Right? We should not remunerate network externalities, because that equates with remunerating the SEP holders for the holdup.
How
That
would
is
we-
the analogy.
How would we measure the value then? How would we separate it out? So in the example of the SEPs, you said, well, we can go back in time and see what the value of the patent was before it became standardized. Here, because it's slowly accumulating the value, that the more apps that become available, the greater becomes the value. How would we know of the the part where the value is not coming from accumulation?
This is the criticism of FRAND, because both in the Advocate General opinion for Huawei and in the US equivalent case, which I can't remember now, what they say is that competition is not a good tool to use here, because the problem is an intellectual property problem, which is that FRAND is a great notion in principle, but in practice it comes down to the negotiating powers of the patent holder and the licensee.
But the question is, and I'm not trying to lay down a pricing because I'm not even well equipped to do so, but there will be a discussion on cost-based versus value-based approaches, right? I would expect this. And I think that the commission or any decision maker in this context could lay down a principle or explain a bit how the value is formed and the role of network effects, right? Because this is something that is not being, it is there, it is the elephant in the room, and nobody wishes to address this.
Isn't this similar to Amazon charging a fee for putting books there and saying, because, I mean, the value I get from buying a book from Amazon as opposed to other people, well, one is that they've got fast delivery, but the other is I know many sellers are available over there, so I can more easily find it, but they charge each seller a fixed rate or some commission that they charge, the formula that they've worked out. Isn't this very similar to that problem then?
The app stores don't charge the same rate, the same access rate, which is another problem that this FRAND, and I'm going to get to the non-discrimination in a minute, because they charge different rates without justification. So,
Could I please coming forward again, online?
Yes.
Yes, thank you. I would like to raise 2 points here. I mean, basically the first, because this slide is titled Economic Value of the Platform. It is undisputable that these platforms have gigantic value, and the value comes from various types of network effects. So this is a misunderstanding, I guess, Andreas, that you had, because you, at least in your formulation, you were only thinking about direct network effects, but just what Farasa said, kind of their classical indirect network effects. And on top, you have these indirect data-driven network effects, which basically say the more people are on one side, the more information the gatekeeper can collect on them, the better they can improve their service in the next period. And from that, and only they can do it, nobody else. So consequently, they can get all the extra benefits and profits, and the other ones can't. So this is a very large value. However, the critical question, I guess, kind of the talk will be going there, is of course to which extent this value should be remunerated by FRAND payments. And here I think, and this is important, that the analogy with standard essential patents is not correct, or say is not appropriate. And the reasons the following. By definition, when I get a patent, I need to have invested in this specific technology first. This is a costly process, which is usually risky, and only if I'm lucky and I'm successful, then I get a patent, and it must be novel and blah, blah, blah. Right? This is not necessarily the case here. I mean, so you started with Article 11, which is on search engines. And here kind of this is the archetypical example where kind of value in the form of data about users' preferences and characteristics was collected as a mere byproduct of the of doing the business. Kind of a search engine cannot help kind of collecting data about what users want and where they click on. I mean, this is coming for free. And consequently, if FRAND licensing for the data, because this is what we're talking about in the context of search engines, if FRAND licensing would mean that kind of now Bing and smaller search engines would have to remunerate Google for their data about users' preferences, then basically they would remunerate them for something where Google did not invest anything in it. And that's a major kind of difference to the SCP case.
But because we've been talking about the app stores, because I said I'm not going to talk about the search engines. They have invested, right, in having laid down the infrastructure, the software infrastructure for a successful app store.
Yes, so there they certainly have invested. I mean, as we could say with a smile right now, and having a look at how Apple reacted to the DMA 2 or 3 weeks ago, kind of they may have overinvested.
It's not entirely comparable with the search engines, because when I started off this project, I was looking at both, and then I said no, it's not comparable, and I need to and I decided to shift the attention to the App Store instead. And I don't say that there are no challenges, and it's very difficult to hypothesize a world where there is competition between app stores, given the duopoly and the fact that in the Apple this has never been possible. But I don't know what is going on in the FRAND negotiation process, right? And whether the network effects are taken into account or not. And I think that trying to start from sort of first order principles from what we have, the sort of accumulating wisdom so far from competition law, SEPs, FRAND licensing and SEPs, I think this is where I stumbled across on trying to draw the connection between Microsoft market power, strategic market power that should be excluded in the calculation, shouldn't be taken into account in the calculation of royalties. And if here we are dealing with a new Microsoft, the equivalent is the network effects that should not be taken into account. I said I'm staying away from laying down a pricing methodology. This is your job. But I mean, I think as a lawyer here, I think I'm trying to contribute to some first order principles to offer something a bit more concretized. Instead of just rubber stamping whatever Apple and business users negotiate. And may I continue just to, yes.
So I think the pricing actually is important, also to understand what these Apple Store are, and the role of the platform is as well is important. Yes, we can look at the fact that in principle, as a developer, you could multi-home pay. There's nothing preventing you from doing that. You need to pay a fixed fee in one store, a fixed fee on the other, but then you can place the software in both. Okay. So and there is two types, if you want, of apps. There are the apps that are, in the simplified word, the ones that are paid apps, forget about the in-app payment, but the ones that they are free. Okay. Most of the apps are free. And I don't know if the platform is getting money since, all, if you want, the advertising takes place outside the platform in that case. So it's already the discrimination in place between the different types of app developers there.
And I think another issue that makes compliance with the DMA difficult is that, from my understanding, is that they offer an access fee and they bundle it together with other services. Say support, mostly software related.
That's more than Apple, probably.
And that is Google more than Apple, but they do, and it's very difficult to see. Complying with the DMA would entail that they unbundle.
But can I ask you one question? The key point here is, forget about being, if you want, dominant market or not. This is a matter of take it or leave offers, basically. The Apple tells this app developer, you pay 30% and you put your app for, I got 30% of the revenues from your, if you want, apps that are paid. That's my business here. The other can say, I don't want to pay 30%. That's it. It's not that you can contrast that. In principle, this number is different. Say, I can charge you as much as you're willing to, all your revenue will come to me because I'm the one that dictates the rules here. So, and this is take it or leave is that there is the problem here, more than the abuse of market power. Is
Exactly,
not,
it is, yeah, it is, I think that is what they are trying to address, this imbalance in the bargaining,
it is
the
the problem
bargaining
there.
power.
That's yeah. That's
That in some jurisdictions, you know, the legal term is abuse of economic dependence. But we can derive principles from competition law, but we agree that DMA is not competition law, right? So we're not trying to say, okay, you have a dominant position and this is how we calculate it. We have decided based on quantitative and qualitative thresholds that these are gatekeepers, tough luck, this is the obligations that apply, right? My very, very timid contribution here is to flag up the network effects and the lessons we can draw from competition law, which is very much as informed, right, in the sense of the remedies, the DMA. I have some more slides. I think the case, another a way to address this outside the context of the DMA is to tackle it as an excessive pricing case, right? And that would have, then we talk about competition, right? But when I'm talking about laying down some principles on FRAND, right? That, as I said at the beginning, would fall short of a detailed methodology, but some overall principles. This is what I was trying to do. I mean, in excessive pricing, yes, there are a lot of thinking, and again, there you need, if we go down the competition law route, then we have United Brands, we have the test. Again, we need to adjust it and apply it in the context of digital markets. We need, again, we will stumble across some difficult questions in the sense that a meaningful cost benchmark should be defined. Should we take into account the value of the wider ecosystem of products, value of the products that stems from intangible assets, the brand, the research, the human capital, and then the Commission will have to come to view what is a reasonable margin to be allowed on top of the cost base to compensate the risk they are taking. So again, we even if we take the competition route, we have to address a difficult question on how you value, how to take into account the wider ecosystem of product and the value that stems from intangible assets, and how you separate these from what happens, the aggregations of this market power, which is the network effects. And then we would have to see whether they're unfair in itself or in comparison with the price of competitors. So even if the Commission were to find that the fees charged were above some reasonable measure of cost, that does not automatically mean that these are unfair or unreasonable, because, well, the gatekeepers would argue, well, look, our ecosystems here have developed enormous value by giving the platforms, you know, an opportunity to develop products, and our fees actually reflect this opportunity. So again, it is how you take this argument into account. The same argument is the one that they will make in the context of the value of their ecosystem. So the app developers would actually say this, our fees is actually a function of our market power in this context. So that is, I think, what Recital 62 tries to do, to give some guidance that derives from exploitative pricing and from SEPs. Now, when we look into non-discrimination, for me personally, I don't understand why some apps, you know, it's based on a very unjustified, unprincipled distinction, why some apps pay a 30% commission fee and others zero. They have tried to justify this on very nebulous ground. The question on non-discrimination is if the DMA requires absolute equal treatment or prohibition of discrimination resulting in anti-competitive foreclosure. And that is, again, another open question in the DMA. The Recital 62 draws a distinction between discrimination and disadvantage. This implies that terms are unfair when they lead to disadvantage vis-a-vis the gatekeeper's same or similar services. So I think that the DMA does not prevent the gatekeepers offering third parties different conditions, provided these do not discriminate against business users. And that is, again, a pragmatic approach that the Commission takes, because it is sensitive to the fact that business users may require some more tailored general conditions. And it is also quite consistent with the approach under Article 102, which talks about equivalent transactions. So it is not that it imposes an absolute equal treatment, and also consistent with the FRAND in the SEPT context that talks about similarly situated licenses. Now, for me, conditions of access is something broader than the fees and the price, and there are various ways in which you can make conditions of access very difficult. You can use sort of the payment cells, update policies that they need to change and comply with, policies around context, security, which is Apple, I think, main argument. So it is the Commission, when looking into the conditions of access, should take a very broad interpretation beyond price. So where are we at the moment? Discriminatory, no more different fees for different developers without justification.
So
Unfair.
can I just ask on this discriminatory part? When you're saying on different developers, there shouldn't be, are you saying different developers in the same category, subcategory, or across the board? Because, I mean, if two people are providing, let's say, health-related app, that, and you charge one fee and the other one different one, then you can see, okay, there'll be somehow disadvantaging one partner over the
Others
other.
might
But if
require.
you're comparing a health where, let's say, someone who's providing a calendar service.
Exactly, in the same category, and that would be complying also with competition law that talks about anti-competitive foreclosure.
But isn't there a deeper problem here that if we have network effects, then this makes no sense at all? If you have network effects, if we agree on these, then it's never the same. You add a product, the whole thing changes. Take away a product, the whole thing changes, right? Because the value of it changes. It's very different to add another 3 apps on the same thing. That adds pretty much nothing, or else it makes me the only game of time. Whichever way it goes, if it changes things, then you don't have anything to keep constant. So therefore, non-discrimination in this context is, I think, meaningless.
I think it's worse than that. If you think about the non-discrimination, suppose it will be to charge all Apple developers a small fee or a small proportion. How many will exit this market? Probably 2 million. You know, it's so much skewed that you have so many that's so small that you increase the fee by a little bit to them because you want to make it non-discriminatory. You're going to produce, a huge impact on the network effect, because many, if you want developer, will start leaving. At the moment, what it is in place, as an app developer, you can choose. Do you want to go for the paid app, or do you want to go for the advertising, or do you want to go to in-app? The platform is simply then imposing, if you want, maybe it's a high percentage, but still you have a choice. So probably those that are more profitable will choose the paid apps versus the others. So I'm not sure really discrimination will help. The developer will produce a change in the network effects, and then it produce an impact that perhaps is worse than what we currently are having.
I think one of the and it goes back to an earlier slide, but one of the fundamental problems with a lot of the fairness and a lot is that we're thinking in terms of equilibrium in that case. In equilibrium, everything is like fine. But the process of competition is very different. Process of competition, things are not the same.
It takes a more static approach.
Yes, it kind of freezes it, but because this is a very dynamic world, freezing it is extremely dangerous, because you could freeze it at the wrong moment, and different moments will give you completely different answers, and then that in itself might be perceived as being extremely unfair to the market participants.
That's okay.
GDPR is ready to use exit of 600,000.
What would be we leave everything to be negotiated between the Commission and the gatekeepers, because when I started off and looking at this provision, I thought, okay, this is a very pragmatic approach, and the Commission is right to stay away from it. But then when I looked also, there are very limited opportunities for redress which comes here. We don't actually know the dispute settlement. Is it only for access? who is going to sit on these panels, what is the depth of the analysis that the commission says, like the DMA will assess, is it just, you know, a ticking box exercise, okay, this is FRAND, will they need to produce a FRAND style publication, what is the level of transparency in these documents? There are many open questions that I find problematic, and also from a sort of a rule of law perspective. And in the beginning, I was thinking this is excellent what the commission is doing, because it's a decentralized approach, a flexible approach. It is not a top-down, and it echoes the general consensus on SEPS licensing, that there are more than one set of FRAND conditions in this specific context. It is very much following the path for good faith negotiations instead of a substantive strategy calculating royalty rates. But I think we should care and we should give some further guidance, because we are accentuating this asymmetry, given that if this is not considered FRAND, the business users have very, and I'll talk about this, very little opportunities for redress. So it is a win-win for the commission and the gatekeepers, but it creates unexpected consequences for the business users, and it increases their costs. So I think that, yes, we should stick to the procedural framework, yes, a light touch approach, but some guidance on how parties ought to behave, and some guidance on what should and should not be taken into account. Or some attempt to define what would be the lower limits bounds of FRAND and what would be the upper ones. And I think we have done this, Commission has done this in the past, and that is my sort of contribution. I'm not going anywhere near laying down the price of the budget myself. I'm not willing to do so. It's very difficult to borrow from telecoms because you cannot even apply a ladder of investment approach, right? It's a access it or not. It's not like we did in telecoms trying to build some competition in the various elements, right? As we move and we go through liberalization. Here it is, okay, tough luck, you open everything, right, to make everything a tough luck. That's the one you open it to competition. So it's again, take it or leave it, a more drastic approach. And the question is, can we, from the experience, the case law, the commission judicial practice, offer some principles? And I think the elephant in the room is the network. I'm pretty much so far from my work of is convinced that, as we said in Microsoft, you exclude actually the market power and strategic market power in this context. Now, in the non-discrimination, you're right, I hadn't thought about this. It creates an equal treatment, creates unintended consequences in the sense that you lose the very sort of an incentive to. Should then this be pursued through an excessive pricing case instead of applying a horizontally and across the board obligation of non-discrimination? Should it be because even if you look at the subcategories and you apply so all health apps will have X commission fee, then again it creates unintended consequences.
Even the excessive pricing cases, we're going back to United Brands case. If you apply that to two-part test over here, that would also cause problems, because that's also based on without the network effects. And even in cases where they didn't have network effects going on, some of these excessive prices cases have now been going on for decades without being resolved, because they keep going back, trying to resolve them through United Brands. Thing. The Pfizer Flynn case has been going on for 10 years. Even right now, it's still not decided, and they've come back within that, not to the cost-based side, but they're now looking at the value-added side of value of the product. So I don't think United Brands is going to be.
One recent piece I was looking at, but not recent piece, one piece I was looking at recently is the CMA's code of conduct for publishers, news publishers and platforms. And there again, they look important. So they have again done work trying more from an economic point of view, not the legal one. I'm trying to synthesize the case right here and try to take out from the cases of principles. And they looked at pricing methodologies purely in several contexts, and they say, okay, look, publishers and the platforms produce some joint value, and they take the joint share of value approach, which recognizes the contribution of both parties. And it is something that I am exploring now as a sort of a middle ground or an alternative. For the first step, I think it would be useful to offer to decision makers what we have been doing so far, how these are comparable or non-comparable to sex, what is the role of competition law or case law in this context, what we should not take into account, being sensitive to the particularities of this market. I haven't looked at the joint share value approach, and it's whether it was successful in the code of conduct.
So I suggest there's another elephant in the room here, especially with apps. And that is, the problem is there are too many of them. It's like books, it's like music, it's like all the rest of it. There is a massive overproduction happening at this moment. And the big problem for consumers is finding the ones that are any good. So the problem is not actually the availability, it is some way of profiling, whichever way it is. And that just leads me to ask the question, exactly what is the consumer harm here that we're worried about? It's not clear that pricing, getting rid of a whole bunch of these people.
DMA is not interesting, right? It is mostly focusing on the business users, right?
Yeah, so it's like IP in that regard, which is like,
I've talked to
just hope it won't work.
DMA officials and they don't care about them.
Then we
If
have
the
to,
consumer finds the ban on self-preferencing useful or not, that is a good empirical question, but it's not anywhere reflected in the preamble, right? It's all about contestability and fairness.
so then let's hope it doesn't work. Because I mean, this is, I think, it doesn't solve the problem, it creates problems. It doesn't deal with the right elephant, in my view, that we have here. And I guess, yeah, it comes to the why should we care?
I mean, in these FRAND type of things, has there been any work done that says we should try and implement some sort of a Nash bargaining solution? Because that would just look at the surplus you're generating and then try and split that.
Yeah.
So.
But they are doing that, sorry, they're splitting the surplus, there's 30% is a splitting of the surplus.
Yeah, it's a split
There's
of.
no distortion, I mean, this is like, what the hell is the problem?
Yeah, to me, can I say that if you look at, for example, on the labor market, why don't you have a single employee to go and say, I want to get that wage to a big company, because you got the wage that you're going to get. But when we have trade unions there, that the trade union are able to voice, isn't it possible to think, maybe to fix this problem, which is, a problem to me of bargaining, is you need to have a counterpart that has enough collection of developers that can say, we don't gonna pay any more than 30%, we're gonna pay 20%.
So solving the collective action problem that business users.
And then if you don't listen to us, we switch up over apps overnight. The key one, remember the paid one are the important one. And that is like you will have a trade, when you say you go on strike. So this is a way if you want to play the game.
So you're talking about a monopsony here, right? In a sense,
but that's the more
by Apple and
that's where we are.
Google. We are in a monopsony, right? And the labor, their forces, their app stores, right?
Yes.
And there you need an association promoting the interests of business users, exerting some constraint. That's an interesting.
So now a legal cartel on the other side.
Andreas, I think, because we should make sure that Jenny has time for a cup of tea.
I have more faith in development.
I would make one cynical comment, which I think we're being a little bit naive in accepting the app store owner's narrative about all these developers providing it for free. Good luck finding a genuine app that is by an independent developer. They're all apps that are free, but they're all designed around generating in-app purchases, and they're owned by gambling companies and big You know,
To advertising.
and not to mention the Spotify problem, that once you download the app, Apple in the past has stopped you from promoting any kind of third-party link to access other services. So, you know, don't think of this as being some incredible altruistic.
No, but it's advertising behind. You can get the money to the advertising. That's what it is. Free. You know.
Well, it depends on the app.
Yeah.
Depends on the app.
Sorry, I just have a question online from Rizzo.
Yeah.
You don't unmute yourself, please.
Hi, yes, thank you. Thanks so much for the interesting presentation. I was wondering, one of the main points earlier on was to sort of consider as a FRAND price, one that doesn't account for the network effects that have built up over time. So I guess the one way to do that would to go back to when the App Store. Sorry?
Then this would be the price would be zero, just give access, yeah, but that was the point,
Well,
yes.
No, I guess, yeah, I mean, even before, you know, before the App Store had one developer, the fee was already 30%, right? So that they set that price before network effects even kicked in. So that, you know, does that mean that the price without network effects is also 30%?
So I think the point here I'm making is that the value attributed to the gatekeeper platform is generated by network effects, right? And not by necessarily superior technology. So a fee that reflects this is unlikely to be FRAND. It is actually reflecting the monopoly power. So the work here, I think the difficult part of this is that if we say that the FRAND access price should not exceed the incremental value of that the platform offers over the next best alternative platform before the network effects are realized. So this necessitates some hypothesizing, and again, forecasting economists come in, of what would be the best sort of next alternative that we don't have in this world. And a world where we would hypothesize effective competition between similarly situated app stores. So this, I think, I've discussed a little bit with economists, is difficult, but not entirely impossible, right? So I'm not saying, oh, you take into account the network effects and you do not take into account the network effects and then do the story. You have the second step of hypothesizing what the next best alternative would be in the sense of having, so we've done this in counterfactual scenarios, we have the tools, and then the economists could offer some models on this. From a legal perspective, I am not entirely, I think this Article 612, if the Commission does not offer some guidance, I'm not talking about a detailed here methodology, a catch-all, this is impossible. I think I am being the pragmatic here. But if it doesn't offer any guidance, that's just an empty vessel. That says nothing. It just hands over a carte blanche or bilateral or multilateral bargaining with huge asymmetries in power, unless we adopt some intermediate institutional solution equivalent to a trade, where you have a collective of business users overcoming this collective action problem and negotiating with the gatekeepers. That could be also very interesting suggestion. So what I'm trying to do in this paper that I hope to share with you by the end of spring is to look at how the concept of sex and how the concept of FRAND has traveled, being very, very mindful of the context it has been applied. The closest comparable is Microsoft. And then looking at also the unfair, the non-discrimination. All these notions in the DMA just don't come out of the blue. They have, the Commission is borrowing from the case of putting all these together. What are the unintended consequences this current situation creates for business users. Actually, you know, they either accept what the gatekeeper says, or the commission will not scrutinize, my understanding is, even the FRAND document, right? And then alternative dispute resolution and good luck. The commission doesn't even have to issue a decision saying, well, actually this is complex. They have nothing to challenge. That I understand why they're doing this, because they want to shield themselves from litigation and a more sort of quick implementation of the regime, but it is problematic, and also from a perspective that there are very little avenues for meaningful redress, and we will end up in 2 years' time somewhere in a court in Europe, a judge having to decide whether this is FRAND, right? And we go back to what we have been the sort of the litigation we have been looking at in SEP. So that is my modest here intermediary contribution as I'm starting to unpack this from a legal perspective, falling short of course, of offering sort of a pricing here methodology. I can highlight the differences between telecoms and platforms, and that is as far as I can go. But yes, I think the network effects and hypothesizing a world of the next best alternative before the network effects kick in is crucial here for our purposes, and maybe colleagues have something to say about this.
Thank you very much.
Thank you. Thank you. Thank you very much.
And now it's definitely time for tea.
I had forgotten that when you present economists, you're being interrupted.
Yeah.
I really had forgotten all about this, but it keeps you on your toes, yes.